Whenever you're ready.
Good afternoon, Judge Higginson, and may it please the court. My name is Derek Ho. I represent the appellants, Hugh Dickson and Mark McDonald, who are referred to in this case as the joint liquidators or the JLs. The district court's bar order enjoining the JLs violates bedrock principles that anti-suit injunctions, like other injunctions, operate on the person and thus require in personam jurisdiction. There is no receivership exception to that rule. A U.S. receivership court's in rem jurisdiction over a state property in its control does not give it worldwide personal jurisdiction. And in any event, the JL's Swiss court claims are not property of the U.S. receivership estate. The court below has no authority over the Swiss courts, and the Swiss courts recognized the JLs and refused recognition of the receiver. SocGen's desire for a global peace cannot justify obliterating settled jurisdictional limits, which are essential to individual liberty and the proper functioning of cross-border insolvencies. The court should vacate the bar order and to the extent it enjoined the JLs from pursuing the Swiss court claims. There is no serious dispute that the district court lacked personal jurisdiction over the JLs. The only question is whether in rem jurisdiction can somehow justify the anti-suit injunction.
Again, you will get extra time, so don't be worried about the clock too much. But a couple background questions. The litigation in front of Judge Godbee has been almost 15 years in full lapse. But am I correct that the relevant hearing is just the June 6th hearing? Is that the only hearing that we've got where the issues in this dispute come up?
I will take Your Honor's word on the date, but yes, there is the one hearing in which counsel for the appellants was present and was told by Judge Godbee that if he did anything more than say good morning, that would be taken as a general appearance.
And then there's the chapter 15th where you filed your objection,
exactly,
which was responded to, but there was never a district court ruling on that. Is that correct? You engaged in
That's correct.
Okay.
And we filed in the chapter 15 case because, as Your Honor is aware, the JLs had previously sought chapter 15 recognition in that proceeding, and a chapter 15 proceeding is, of course, the place where foreign liquidators like my clients come to the U.S. court to seek the assistance of U.S. courts. So our view was that it was a natural place to file that objection.
Two last, just sort of setting the table. Not even though the briefs, to my reading, allege each side saying the other is in breach of the protocol, there is no issue before us, or even in the Chapter 15 proceeding, that either party has formally stated the protocol was breached?
I believe that is correct, Your Honor, and indeed there is an arbitration clause in the cross-border protocol, so that dispute, if it were actually to be raised in that fashion, probably would not be in federal court.
And the reason I was asking these early questions is I saw in your brief, in page 21, you'll remember it, the alternate request for relief. If the court does remand, it should vacate the district court scheduling order, antitrust injunction, and instruct the district court consider all the JL objections. So the logic behind that alternate form of relief is that, don't let me put words in your mouth, but is that built on cases like Cruzan and Payne-Weber, that in fact you should have been able to object?
Precisely, Your Honor. If the court simply finds that it was error for the district court to refuse to allow us to object without imposing the pain of a waiver, then there is a procedural possibility of sending it back to the district court to at least, with the instructions to at least consider our objections. That's our backup form of relief because we think that it's a matter of law, and now that the issues have been fully briefed before this court, as a matter of efficiency for both the court and the parties, it would make sense for the court to actually address the personal jurisdiction objection.
And again, you'll have more time because otherwise I'd just keep talking, but the refrain in your brief is a strong refrain, right? It is this district court created a catch-22, set a waiver trap. But it's equally plausible to say Judge Godbee, in spite of his experience and talent, may just have had a faulty premise. And that premise is that you would have to waive your objection to plain personal jurisdiction in order to object to the bar order.
We certainly agree that that's a faulty premise, and putting the maybe slightly heated rhetoric aside, I think that's just we would agree with that as a description of the waiver trap that we were put in. We don't think that that's consistent with Payne-Weber, and we tried our best to lodge the substance of our personal jurisdiction objections despite that, and we're now before the court asking this court to rule on those objections.
Now, separate from that, and I understand that logic, what about just the observation that 10 or 13 years ago, you initiated litigation in the Chapter 15 matter. You went all the way to trial. It's hard for me to think, oh, well, that isn't availing yourself. It's unfair for you to now expect that adjudicating who partitioned the world which way would be in front of Judge Godbey. Is the flaw to that 1510?
Your Honor, absolutely. We would say that 1510 specifically says that the Chapter 15, our effort to obtain recognition.
Do you have a case that says 1510 extends beyond just resolution of the status of your client? In other words, that it would extend hereafter to what I see as essentially a battle over the protocol?
I don't think either side has a case that specifically answers the question whether 1510 applies to a case like this.
Those are all helpful answers. Go ahead.
Frankly, Your Honor, apart from the waiver trap, there's no serious argument in the appellee's brief that there is traditional in personam jurisdiction over the joint liquidators. That they put all their eggs in the basket of the argument that you don't need to have in personam jurisdiction because the receivership estate operates as through the mechanism of in rem jurisdiction. But I think the clear answer to that is that the Supreme Court has said, dating as far back as Cole against Cunningham, that whatever the court's in rem jurisdiction may be over property that is within its custody, that does not justify an in personam injunction. Injunctions operate on the person. They don't operate on the property. Indeed, the whole point of this injunction against the people that I represent is that the court doesn't actually have control over this property. The property at issue are claims in a Swiss court under the auspices of that court where my clients and not the receiver have been recognized as the duly appointed plaintiffs. And so it's precisely because the court below doesn't have in rem jurisdiction that it tried to use the mechanism of an in personam injunction. But the two require separate sources of authority, and here there is no in personam jurisdiction over my clients.
One argument for in personam would be that 1510 is narrower, and you availed yourself later by filing in that. But that...
Again, I think that argument is waived, frankly.
It's waived. Okay, so waiver plus 1510. What about a case like the SEC versus Stanford Bank? Judge Jones's opinion, and I'm sure you know it well, but she says, talking about Kaleda and other cases, they explain that in rem jurisdiction over the receivership estate implies the district court with broad discretion to shape equitable remedies necessary in order to protect the estate. Is the answer, well, only domestically, not internationally, or is the answer there are two estates here, or is it both?
Let me make sure I'm answering Your Honor's question. I think answer number one is that statement does not address at all the separate requirement of personal jurisdiction if the remedy that the court wants to effect is injunctive. So that's point number one. To the extent that the question is, does the court's in rem jurisdiction even extend to this particular property? Yes, I think fundamentally the core disagreement between the parties is the appellees talk of this as a single estate, but that's just not consistent with the record. If you look at the cross-border protocol, the cross-border protocol specifically states that there is a U.S. estate and an Antiguan estate. There are two different estates, and the estates are separate juridical entities created under the auspices of two different courts. They may have the same, many of the same purposes, but they're separate juridical entities. More than,
Racing to the court is built into the system?
well, the possibility of racing to the court is built into the system. There's always some degree of friction in cross-border insolvencies and the need for cooperation. But the cross-border protocol was designed to try to reduce that friction, and that's where the parties agreed that there wouldn't be a race to the courthouse, that the receiver would be authorized to continue to bring the claims that it's authorized to bring here in the United States, and the joint liquidators would be authorized to continue to bring the claims they're authorized to bring. And again, the receiver was specifically denied recognition in Switzerland to bring these claims. That's recital Y of the cross-border protocol. So there's no argument here that the receiver somehow has control over the Swiss court claims. He simply doesn't. The Swiss court said, no, the JLs have control over those claims. So there are two different, it is, it's absolutely,
I thought it was sort of phrased negatively, that you need approval to sue in the US, implying therefore you don't need approval of Judge Godbey to sue overseas. But that isn't necessarily saying we've partitioned the world, Spain, you get this, Portugal, you get that.
I think Your Honor is referring to Section 3.1 of the cross-border protocol, and I think it speaks for itself in terms of the language. We certainly think that it's clear that what that means is that the world is partitioned, but I think to the more specific point of whether the receiver is recognized in Switzerland, it's recital Y, and I think it's, I'll get around to it's ROA 48763 to 64.
408 what?
763 to 64. And what that recital says is that the Swiss court, that FINMA, which is a Swiss agency, recognized the JLs and, quote, rejected the concurrent request of the receiver to recognize the appointment orders of the U.S. court. So I think it's quite clear that the receiver was refused recognition in Switzerland. Moreover, we have, as part of our motion to supplement the record, appended what is at AX 433, and that's an email from the receiver in which he specifically acknowledges that he was refused recognition in Switzerland. So again, if the question is in rem jurisdiction, and again, our principal argument is that in rem jurisdiction can't substitute for in personam. But the second argument is that even under in rem jurisdiction, this court doesn't have in rem jurisdiction over these claims. And the easy proof of that is that this court, the court below certainly can't control the claims in Swiss court, and even the receiver cannot control the claims in Swiss court.
But they come out of the same bank, and everyone's aimed at the same investors. So it just sounds pretty connected, to use the words in some of the case law. It's pretty derivative of this estate. We're trying to get all these investors the money out of that Swiss bank that it might owe.
It's actually not the same beneficiaries of the two estates. This is not in the record, but there are differences between the two sets of beneficiaries. Specifically, the Antiguan estate benefits creditors that were not investors. So it's but this is not in the record. What is more important, I think, and is in the record is that even if the beneficiaries are overlapping, that doesn't change the fact that there are two different estates. There can be different estates created by different courts across the globe, and the power of the in rem power of a U.S. receivership court doesn't extend to property that's outside its territorial borders. Receivership courts follow the law, and they follow traditional equity principles. So you can think of this no different than a car or a house. It would be absurd, I would submit, to say that a U.S. court has in rem jurisdiction over a car that's parked in a garage in Switzerland or a house that's located in Switzerland. That's just not how our in rem jurisprudence works. The court has to have actual control, custody in the terms of this court's cases, of the property in order to have in rem jurisdiction. So the fact that it might be related, it might have something to do with the Stanford estate, that's not enough to bring claims that are pending in a foreign court.
It would be if it were in the U.S. courts, right?
If the claim were pending in U.S. court.
And it were related.
Yes.
So that it's sort of, is it Waffen-Schmidt? Am I pronouncing it correctly? The case that says the receiver's authority extends just assets in the U.S.
I think that is one of the cases, but I think that I would say that the line of cases that stands for that proposition goes back to the very basic notion that in rem jurisdiction is about a court's power over property that's in its custody or control.
So relief here, you're saying strike the anti-injunction portion, but Societe Generale is still stuck owing 157, and the receiver can't undismiss the U.S. claims. The deal's intact in all respects except you face no consequences for pursuing the claims in Switzerland. Have I stated it correctly?
You have stated it correctly, and that's not because of anything we did.
No.
By operation of the provision in the settlement that essentially says that the parties, the receiver and Societe Generale, will proceed with the settlement even if the bar order is modified, which shows that the bar order is not an essential element of the settlement. It's not even, frankly, a material term of the settlement because they're willing to go forward with it even if the bar order is modified. So, I mean, I think that what's pretty clear here is that they tried to throw this in as a way of seeing if they could get everything across the world resolved, knowing full well that there was a very real risk that that wouldn't fly. And then they both agreed that if it didn't fly, they would still go forward.
Am I being naive, or will the beneficiaries in Antigua get a portion of the 157, just as if you pursue the Swiss litigation, you get a result, you settle it, people here will get a portion? The protocol still requires a sharing of any recovered assets? Is that fair?
It would be distributed pursuant to the protocol, and again, there's not complete overlap between the beneficiaries of the U.S. estate and the beneficiaries of the Antiguan estate. So, and in a way, that's why there is a distribution agreement in the protocol.
Yeah, of course.
Sorry, I just want to make sure I didn't.
Yes, no, thank you.
Just two quick questions. First, on this in rem jurisdiction idea, if I'm understanding the theory of the district court and the receiver, every dollar that would ever be paid to the JLs is actually property of, if it really is just one race, right? If there really is just one piece of property and it happens to be the estate that's in front of Judge Godbey, then wouldn't they have the right to go after the JLs for every single dollar paid to them to say, in fact, that's actually a dollar should have been paid to the receiver? Is it really that limitless?
I think that if you conceptualized the entire estate as one estate that's only pending in front of Judge Godbey, that probably would be the logical implication. But of course, that's not consistent with the protocol.
Yeah, I certainly understand that. But the theory of it seems to be if there's just one estate, there is no separation between the United States and Antigua or anywhere else, then every claim that your clients are asserting are in fact belong to Mr. Janvey, and every dollar that you ever recovered on behalf of creditors should have actually been paid to Mr. Janvey.
They don't quite come out and say that, but that certainly seems to be the implication of their theory.
And also, the entire protocol order is an empty, I'm not sure I understand what the point of the protocol order would be at all, because there's no protocol to have. If in fact Judge Godbey has universal jurisdiction over every claim asserted anywhere in the world, then why would we have a protocol order at all?
I would agree with that, and I would maybe restate it as follows. Even if somehow you could conceptualize this as one estate, the parties, including the receiver, agreed to divide that estate up into multiple pieces. And so, the cross-border protocol, I think, is just confirmation that nobody in this case proceeded as if there was a single estate where the U.S. court gets to decide everything. The whole problem that gave rise to the cross-border protocol is this was a multi-jurisdictional cross-border insolvency involving, again, an Antiguan company at the end of the day. And so there was an effort to coordinate all these cross-border efforts if the whole time there was only a single estate, none of that would have been necessary.
And what is exactly the legal status of the protocol order? So I got was that entered? In which docket was that entered?
That was entered, I believe, in the case below.
In this docket. And is it? It's not exactly a contract. It's not exactly. It's
a settlement.
I'm sorry.
It's a settlement, Your Honor.
Settlement. So, is that what? How do we interpret it the way we normally interpret settlement agreements, like a contract, basically?
I think so.
Okay. Last question, and it's about this. I don't even know how you describe it, but the idea that this bar order is, with or without it, the Swiss bank agrees to pay the $157. So I was looking through the bank has a series of citations to other settlements and other bar orders, and I was going through them, and it's interesting. There's at least one, the Greenberg-Torek one, has a very similar clause that says that Greenberg isn't allowed to withdraw if the bar order is modified on appeal or whatever, but the others don't, which does make this look a little bit weird. On the other hand, the others have things like if the bar order is modified on appeal or is affirmed and entered by the district court in exactly the same way, then either side has the opportunity to withdraw. So it looks like when you're looking at these, they don't look like contracts of adhesion or forms or templates. It looks like they're sort of being negotiated deal by deal, which makes me wonder if this isn't actually part of an important part of the agreement between the receiver and the Swiss bank.
Well, I think, Your Honor, that whether it's a contract of adhesion or not, the fact that the parties specifically negotiated in such a way as to make modification of the bar order tolerable is evidence that the parties specifically agreed, not because of some form or contract of adhesion, that the bar order, to the extent it bound my clients, would not be material. So I think that actually supports our position.
And is there anything to be made of the fact that they did this, at least with respect to Greenberg-Torek?
Your Honor, I don't, obviously we were not parties to any of those settlement agreements, so I can't, I guess, think of any particular reason why that would be significant here, but that may be a question for the bank's counsel as well.
Just to press you a little on the waiver, since they have put a lot of attention to that, do you agree that in terms of our assessment of whatever we'll call it, waiver or appellate standing, even in the context of an injunction, we're applying the three-part test of participation, equity, and personal stake?
I think that this court's cases actually create a bright line test that says that if a non-party is actually bound by an injunction, they have appellate standing. Now, I think you can say that that is an application of the three-part test because they have a personal stake, and that personal stake, being actually bound by an injunction, is sufficient under Castillo. But I think it amounts to a bright line rule, so I don't think the court has to go through.
It's a little odd because the first prong, you didn't participate. You couldn't, you didn't. And equitably, if your own law is correct, Payne, Weber, Cruzen, that you could have participated without surrendering your objection, then as I go down the list of three, we're putting a lot of weight on personal stake.
I think as to participation, I think the Loop case that we cited in our 28J letter makes clear, or Lupe, I'm sorry.
No, you're probably right.
Makes clear that the participation can be in a different but related proceeding. That was the holding of Lupe, because that's exactly what happened there. So we think that if participation really is important here, our participation in the Chapter 15 proceeding qualifies under Lupe. But I would agree with Your Honor's more basic point that the reason why cases going back to Chagra and Castillo and Mays say that if you're bound by an injunction as a non-party, you have appellate standing, is because they recognize that the personal stake really is sufficient in that circumstance.
Thank you, counsel. You have full rebuttal time.
Thank you, Your Honor.
And Noelle Reed for Societe Generale. Noelle, my daughter's name. Okay.
Powers have gone first, given the nature of the questions asked, as he will be addressing in rem and in personam jurisdiction in the Anti-Injunction Act.
Well, I don't mind if you realign, if he'd like to go first. I tend to think of things freshly. You want to do it?
I think it's directly responsive to most of the
That's a
questions.
thoughtful
I
point.
don't mean to put Mr.
Come on
Williams
up.
on the spot.
And, yeah, and again, the same thing, you have 5 minutes, but you see I consume time for people, so I'll be generous.
Thank you, Your Honor. I forgot the things that I need to see with. May it please the court. The bar order in this case is one of 15 bar orders that the district court has entered in the Stanford receivership, 14 of which are now final. This last one, pending this appeal. Due in no small part to the district court's authority to enter bar orders like this, the receivership will at the end of the day have recovered more than $2.7 billion. To achieve a result like this, or really to achieve any result at all, it is necessary that the district court have the ability to assume and maintain exclusive control over receivership property. And let me be clear, because there was a question asked about what about a fight for every dollar that the JLs recover or every dollar that the receiver recovers. The Chapter 15 proceeding, the one that was much discussed, was a proceeding through which the JLs wanted to recover every dollar the receiver had received. Every dollar. Judge Godbee considered that question and decided that JLs should not be entitled to recognition other than perhaps to take depositions if they met with a bunch of stringent conditions here in the United States. He refused their recognition on the grounds that the Antiguan court actually had no reason to be, coming into the United States and seeking receivership assets or assets the receiver had recovered regardless of where they came from.
If you really are right that there's just the one estate, then if the JLs recover $1 in France, that's really Mr. Janvey's dollar, right?
Yes, but the point isn't that there's just one estate. The point in this case for this appeal is there is one set of claims. We acknowledge there are two different estates. That's just a practical reality. Well,
if there's two, I'm really confused. So are there two estates or one estate?
There are clearly two estates.
Okay, because throughout the brief, you and the Swiss bank go say over and over and over again, there's not two estates. There's just one estate. It's all the same claims. It's all the same creditors. It's all the same people. So I'm confused by, if there's two estates, are there two races, R-E-S, plural, when I say race?
There is one race. There are two estates. There are two different courts. I mean, Judge Godbee has recognized this from the beginning, and this is what he recognized in the Chapter 15 proceeding. And in the Proskauer case, by the way, when there was an appeal from the Proskauer. The judge said, look, I get that there's two estates, but there's only one set of claims against Proskauer. It's Stanford International Bank's claims against Proskauer. The Antiguan court has asserted jurisdiction over those claims. The U.S. court has asserted exclusive jurisdiction over those claims. Naturally, there is competition over those two sets of claims, but that doesn't mean there are two claims. It's one claim. It's Stanford International Bank's claim against Société Générale.
And I thought that the entire point of the protocol order in every piece of the course of dealing between you and the JLs was that, yes, there may be one set of claims in the sense that they belong to Sybil.
Yes.
But we're going to treat those differently, such that Sybil's claims in Switzerland are different than Sybil's claims in Dallas.
No, to be honest, the entire point of the protocol, the principal point of the protocol was to resolve disputes between the JLs in Europe and the Department of Justice that was trying to get assets of SIB in Europe. And the question was, how are we going to figure out what to do with those assets, and how are we going to figure out how to stop all this litigation between the Department of Justice and the JLs, and also to stop the litigation between the JLs and the receiver in the United States. That was the principal purpose of the protocol.
So can we go back to your first answer, which is there's two different races, right?
There's one race.
There's one race and two estates.
Yes.
So how is the one estate, there's an estate here that involves the same race as an estate in Antigua?
Yes.
And so the jurisdiction of the federal district court sitting in Dallas goes where?
Is here in Dallas, because the district court determined in the Chapter 15 proceeding, which is a final judgment and which was not appealed, and to which these individuals on the other side are a party, right? So we can't contradict it now in this court. Determined that the center of main interest, the principal place of business of Stanford International Bank is here in the United States. So from the perspective of the district court, This is where those claims live.
Well, you say at home throughout the brief. You and the Swiss Bank both do, which it's quite confusing, right? Because they're not at home in Dallas, they're at home in Houston. So I'm not really sure. At home is a completely different jurisdictional concept, and so I'm never quite figured out what that means. But maybe I can get at this question in a way that is that can at least abstract away from some of the confusion in this case. Can we talk about a different form of in rem jurisdiction? Let's talk about bankruptcy for a second.
Yes.
So let's imagine an Irish debtor, citizen of Ireland, lives in Ireland, makes millions of dollars in Ireland, buys millions of dollars of property in Ireland, and engages in all sorts of transactions with an Irish bank and Irish real estate, Ireland, moves to the United States, gets into a series of commercial disputes, avails himself of bankruptcy protection, and gets the Section 362 automatic stay provision.
Yes.
Right, by filing for bankruptcy in the United States. Does that or does not apply to all of the litigation going on with creditors in Ireland? Yes or no?
I don't know the answer.
The answer has to be no, right? I mean,
Don't
at
know
least
the answer.
if you could find a case that would suggest that the automatic stay would apply to Irish creditors involving Irish property, Irish transactions, things that were done in Ireland, I would love to see it. I've looked for it and I can't find it. In fact, but I can find lots of cases that say that's obviously in rem jurisdiction as to the estate, clearly, right? With all of bankruptcy is premised on that idea. And the anti-suit provision, which is effectively what the automatic stay is, requires in personam jurisdiction and would never apply outside of the United States, even though Section 362, by its terms, purports to apply extraterritorially, right? It applies to all the property anywhere.
So I think I disagree with the premise, which is, and this goes back to what the question in this case is. The question is, does the court need to consider its personal jurisdiction as to its broadly applicable order? And the answer is no. We are not here on an appeal from a contempt finding. We absolutely are not. And so the question is, did the district court have the authority to enter the order that it entered? And of course it absolutely did, just like the bankruptcy order would be an order of general applicability. The court didn't have to decide, are there debtors in Ireland are there creditors in Ireland? And do I have jurisdiction over them? You don't have to consider that before you can enter the stay order.
Well, so this is a great question. So let's go with it. We'll use your terms of it. So I'm a bankruptcy judge. Say I'm a bankruptcy judge in Houston, and I have this Irish debtor in front of me. And I say, hey, listen, I see over there across the Atlantic Ocean, I see millions and millions of dollars of things that I can't touch because there's no case, as far as I can tell, anywhere in the United States that would give me the power to enjoin litigation and issue an anti-suit injunction against a bunch of Irishmen. So what I'm going to do instead is I'm going to enter a scheduling order, and I'm going to say, hey, yelling across the ocean, speak now or forever hold your peace. Come in here and tell me why I can't enjoin you. I know I can't do it because I don't have in personam jurisdiction over them, but I'm going to make them come here to give me the in personam jurisdiction. Say, come now, speak now or forever hold your peace, or you will have forever waived your objections to my anti-suit provision. Could I do that if I was a bankruptcy judge in Houston?
I don't know whether you could, but that is so far afield from what happened in this case.
And how is it different?
There's no argument, number one, that they waived their personal jurisdiction objection, right? Because think about the Proskauer example. Proskauer, there's a broadly applicable bar order entered. The JLs came in after the fact and said there's no personal jurisdiction. The judge engaged in that analysis at that time and found there was no personal jurisdiction. So obviously that's not what's happening in this case. The second thing I would say is the Petro-Saudi case from the Ninth Circuit actually said if you've got personal jurisdiction over the debtor here, you can direct somebody, a foreign bank and a foreign land, to send the money back. Whether they will or they won't is a different question than whether you can direct them to do so.
So I'm glad you brought up Proskauer. Do you think that Judge Godbee was wrong when he said, you're right, actually, I can't issue this anti-suit provision against the JLs in the Proskauer matter? Was that incorrect?
We don't have a position on it, Your Honor. He found there was no personal jurisdiction at that time under those circumstances, and he also found that under the circumstances he was not going to order the Antiguan court. He was not going to order the jails not to do something. His principle, or the resolution of that was, I'm going to go take this, I want you to go take this to the Antiguan court, and you ask the Antiguan court what the Antiguan court wants to do with my order. I think that was an appropriate outcome.
Well, let me ask it this way. Is there any way that Judge Godbee could have been right there and that you can be right here? Does that make sense? So what set of circumstances could Judge Godbee be correct to say, you know what, you're right, JLs, no personal jurisdiction over you in the Proskauer matter, yet the receiver is correct that there is personal jurisdiction here? What would separate the two cases?
So we're not taking a position on whether there's personal jurisdiction here. The point that we're making is Judge Godbee had authority to enter the order. Now, what happens with the order once it gets to Antigua or it gets to Switzerland is an entirely different matter, and it's up to those courts. But he had the authority to enter the order, and he concluded he had the authority to enter the order in that case, which he was correct about.
Through in rem. So if suppose, just hypothetically, that I were to disagree with you about the in rem thing, right? And I think you do need personal jurisdiction over the JLs. You're saying you don't have a position, so what would be the result?
So there's no in rem jurisdiction.
By hypothesis. Suppose I think that if you're going to issue an anti-suit injunction using the power of the federal courts to tell somebody upon pain of contempt you cannot do something, you need personal jurisdiction. Just imagine that that's my view.
I see.
Then what would we do, or what would I do?
Well, I think my colleague from Societe Generale will answer that because we don't have a position on personal jurisdiction in this case.
Okay.
You don't have a position of personal jurisdiction.
Well, we don't have a position that there is personal jurisdiction
What was
over
the
the
position in
JLs.
the Proskauer case? They filed an objection. What was your position?
They did not file an objection to the order, and they eventually objected to the judge holding them in contempt. We didn't take a position in that. That was between the JLs and the Proskauer. And the court's conclusion was there was no personal jurisdiction, but the bar order would remain in place, and the Antiguan court would
Then
determine
just
the
speak
effect.
to the cases that I asked your friend, Cruzon and Payne-Weber, which they cited in their notice of appeal.
Right. So
How could we distinguish those?
you can distinguish them because
Wouldn't the jails have had the ability to object while preserving their argument that there was a lack of personal jurisdiction?
Sure, but they had to come into a court and assert the objection. Judge Godbee, it wasn't on pain of penalty of being put in prison if they talked at the hearing. What he said was, if you talk, I'm likely to find that you waive personal jurisdiction. It either would or it wouldn't. That's a legal matter that could then come up to this court, but to just sit silently and not voice the objection is not appropriate. They have to be making an argument in the district court. If the district court is incorrect in finding there was a waiver of personal jurisdiction, then this court, as a court of review, not a first view, has an opportunity to consider that issue. And as to the specific question about Payne-Weber and Cruzan, the question to me is, have you been hailed into court? If you've been hailed into court, then you assert your personal jurisdiction objection. If you show up in court voluntarily and you editorialize about a settlement in a case that you're not a party to, that could be a waiver of personal jurisdiction. But again, our argument here today is not that the JLs have waived their personal jurisdiction. That'll be for my colleague. Our point is the court had in-rem jurisdiction over these causes of action, a unitary causes of action. And because it did, it had the authority to enter the order, which is the only thing the court needs to be concerned with today.
You were the lawyer involved in the litigation that I described earlier, the SEC case, 2019.
The Lloyd's case? Yes.
Well, Judge Jones, writing for the court, is very emphatic. You cannot extinguish third-party claims
Sure.
if they are, and the word she uses is independent.
Right.
So you would say there are independent estates, but not independent claims?
The claims are unquestionably owned by Stanford International Bank. The difference in that case was you had Stanford International Bank who had ownership rights in insurance policies. You also had other people who were former employees who had their own independent rights to those same insurance policies. What Judge Jones said is, I'm not going to allow you to extinguish the third party's rights in these insurance policies, which are entirely independent of Stanford International Bank. That's totally different from this situation where both parties are trying to assert claims of Stanford International Bank. I mean, this goes to the basic principle that the receivership court has the ability to exercise its authority over the assets of the receivership estate.
Well, but the cases that say that all seem to say up and to the border of the United States.
I don't think they do, Your Honor.
Well, what about the Waffen-Schmidt case?
I think I would point, Your Honor, to the Petro-Saudi case. Right, the Petro-Saudi case where the court took interim jurisdiction over the assets of a debtor and then directed a foreign entity to send the debtor's assets back to the United States. I think all of the cases that we cite talk about you can enter an order against the world. That's number one. And number two is this isn't outside the United States. This is an asset that belongs here. And that's been determined by a final judgment that is not.
Last, because we have been generous, but thank you for answering the question. The last question is, the briefs talked a lot about multiple settlements containing bar orders. Did any of those involve the JL? And did any of them involve bar orders that explicitly prevent or would hold in contempt people who pursue foreign proceedings. Two-part question.
Yes.
All these settlements that have bar orders, how many of them involved the JLs? How many of them were explicitly aimed at litigation outside the United States?
Well, they all involved the JLs in the same sense that this one involves the JLs. The JLs are not named in the bar order. The universally applicable bar order applies to them. That's number one. They all do that.
I thought this bar order was specified specifically that Swiss litigation. No?
The settlement agreement does name the Swiss litigation. The bar order is the
Is there anyone
same.
like that? Any other settlement agreement involving a bar order that names explicitly foreign litigation?
Well, I think I heard that I don't know. I think the answer is that if we're talking about this class of claims, that is the bank claims and the law firm claims, where the idea was, and this is the idea of 3.1, is we don't have an agreement about this. This actually is a race to the courthouse, so to speak. Okay, so we don't have an agreement about it. In that class of claims, we have settled 9 of them, and 8 of them are final.
Very last question before she steps up. Would you agree if you don't prevail that Societe Generale is stuck with 157 million or not?
I think if what you had described, which is that you would say that this is all respects the same, except that the injunction doesn't apply to the JLs, I do agree that the $157 million would still be owed to the receiver.
Okay, thank you, counsel.
Yes, thank you.
Thank you, Your Honors. May it please the Court, Noelle M for Societe Generale Private Banking Suisse, which I will say only once and thereafter refer to as SG or SG Suisse. I would like to address first the question, I think, Judge Higginson, that you last asked, a slightly different aspect of that question. Were there any settlements that involved the JLs? The question you asked was whether there were other settlement agreements, I think, or bar orders that specified that Swiss litigation. Recall that in the record, as best we can tell, because there was no evidence with the objection of what those Swiss claims were or when they were filed. Nothing at all presented to the district court about those claims, other than the ipse dixit with no support in the objection itself. To the extent we can tell from the documents submitted on motion practice in this court, there was a claim first filed in 2019, the JLs allowed it to lapse. There was a claim filed in 2020, the JLs allowed it to lapse. And then the French document that's been submitted to this court on appeal in motion practice is dated, I believe, 2023. So those claims didn't exist when most of those settlement agreements were entered into. I can tell you, as the person who negotiated the settlement agreement, that we named all litigation that was pending at the time of the settlement. And that's the only reason that it was specified there and not elsewhere. I do think it may be relevant to the court, however, that the JLs were a party to a settlement in this, in the court below with Kroll that included a requirement that the very same scheduling order with the very same requirement of consent to jurisdiction be included, and the very same bar order applying to the world be included as part of their settlement. And that's at ROA 64542, 64546, 64550, and 64532. So the joint liquidators have in fact participated in the court below in settlements that required precisely the same, quote, waiver trap to which they purport to object here on appeal. I'd also like to address the court's question about Chapter 15. 1510 states only that the sole fact of the Chapter 15 petition does not subject the party petitioning for recognition to jurisdiction. It does not immunize that party for later conduct in either the Chapter 15 proceeding or other proceedings. And we'll get in a moment to Judge Godbee's Chapter 15 order, which specifically stated that the order was conditioned on the JLs agreeing to certain conditions, including that the court could condition their participation in litigation on whatever the court decided was appropriate. And that's precisely what the court did here. I want to address primarily in my argument the purported waiver trap, which is no trap at all. It's a choice. It's a choice that every litigant has to make whether to submit to the court, to the jurisdiction of the court to seek affirmative relief, or if a court says that you may lose the argument that you're raising, whether to pursue that argument and take a loss to the Court of Appeals or withdraw and waive it.
Well, respectfully, it may be in the sort of commercial litigation that we're talking about here, and I would love to hear your argument on that, but it's certainly not the choice that every litigant makes in the cases that we see, right? We see injunction cases all the time, and I've never heard or seen a case where a judge tries to enjoin a party before establishing personal jurisdiction over that party.
To hold that the court would have to assess jurisdiction over every party to whom a receivership bar order would apply, there were 18,000 claimants in these, I believe, in the receivership. It would bring receivership settlements to a halt, and it's not the standard that has been adopted in this court in any case that's been cited by any party. Receivership orders are permitted in order to try to collect the rest of the estate in one place, distribute it fairly. And you asked a question, I believe it was you, Judge Oldham, about what was the point of the cross-border protocol. It very clearly dealt with the frozen assets in particular countries and actually dictated how those assets would be divided. The remaining provisions are simply an agreement not to agree, to say we can proceed on our merry way and have what consequences we have, and should we recover assets, we'll talk later about whether to share those assets and how. Nothing in Judge Godbee's orders or in his recognition of a Chapter 15 non-main proceeding ceded control of anything about the rest of the civil estate to the joint liquidators. He simply said, we'll deal with that when we deal with that. You'll conduct yourself as you do.
Is the bank's position that 100% of the civil claims belonged to Judge Godbee and the receiver from the day of the non-main, the Chapter 15 order? Is that the idea?
Yes, with one caveat. Again, there's no evidence before this court or before the district court of what the Swiss claims are, or even that they have actually been lodged or filed. It simply wasn't presented. So I suppose in my imagination I can theorize that there could be a true in rem type claim, that there could be, for example, frozen assets, that maybe because the joint liquidators are the ones recognized in Switzerland are uniquely in some joint liquidator estate. Here, though, we're not just dealing with the bar order, we're dealing with a release of claims. And, I would analogize this, Your Honor, to if my son is injured in Texas and my ex-husband lives in Colorado. I don't have an ex-husband, hopefully he won't listen to this argument, but I sue in Texas. I sue a number of defendants, and I recover fully for all of the injuries that he suffered. I'm the recognized guardian here. My husband can't go to Colorado and say, well, that's not where I'm the recognized guardian, and so sue those parties again for all the same injuries and recover a double recovery.
Well, he may or may not be able to sue in Colorado, and you're totally right that those defendants would then tender as satisfaction of whatever debts he had, the judgments that were paid to you. But just under your hypothetical, the Texas court would never, under any set of circumstances, enter an order against your hypothetical ex-husband in Colorado, preventing him from doing anything if he had never been to Texas.
But it might well enter an order releasing all claims, and that's effectively what the bar order does. It's just the next step to saying you can't pursue these claims. And again, we're only asking...
Please, no, please.
We're only asking that the bar order enter. We think, frankly, and I'd like to get to my argument, that they actually have submitted to jurisdiction in the way that they submitted their objection and by going beyond an objection to personal jurisdiction to argue the merits of the settlement. It's our position that they have, in fact, submitted to jurisdiction. So...
Can I just pause you for a second?
Yes,
Before we move on to that, and I'm sure Judge Higginson will be gracious with us, because I just want to make sure, you mentioned the idea of this sort of hypothetical frozen assets, and I want to make sure I understood what you were trying to say. It's at least possible, right? We don't know. We don't have access to the PACER docket in Switzerland, so who knows what is or isn't going on in Switzerland. But it's at least possible that the claims that were here in the United States against your client, let's call that X, right? There were X number of claims for $157 million, and it's at least possible that there is, and Mr. Ho has said, well, it's not in the record, but there's other stuff. So let's call what's going on in Switzerland X plus Y. What would be Judge Godbee's ability to enjoin or order a release and enjoin pursuit of Y? Did my variables make sense?
And I don't mean to dodge the question. I don't know without identifying what they are, and I think that that is a fundamental problem in the record that's before this court on this
And I
appeal.
totally hear you on it, but can you just, if we can abstract away from the record and just think about it hypothetically for a second, if it were true that there was a Y, right, that we have X here and we have X plus Y there, so that's the overlap, right? You have X in both jurisdictions, and let's just go further and just agree that Judge Godbee can order a release of the X because that overlaps. Could he enjoin a release of Y?
I want to make sure that I understand your hypothetical. So there's a Y claim that couldn't be brought and doesn't overlap in any way the receiver. Could he enjoin that? If it is somehow unique to Switzerland and to the jail's recognition in Switzerland, and by that I mean a claim that could not have been brought here. So let's say there's a Swiss law that says only a Swiss citizen or a recognized representative in Switzerland may bring this particular cause of action. I can imagine that could be a piece that Judge Godbee could not enjoin.
And I appreciate that, and we can quibble about the contours of whatever that Y is. Is it broad? Is it narrow? Is it about Swiss law? Whatever. But I appreciate your candor in the question. But what I don't understand is why that doesn't just completely vitiate the bar order in this case. Because if you don't know what the Y is, or is there a Y, all you know is that there could be, and it's possible that Judge Godbee can't enjoin it. Then we can't enjoin first and ask questions later. Like that's one of the.
But I
turn
think that
equity upside down.
I'm sorry, I don't mean to interrupt you,
Please.
Judge Oldham.
No, please.
But I think that brings us back to the gaping hole in the record created by the joint liquidators. It was their obligation to identify what that was in their objection. They had to present something to the district court to say this is something different. And I want to take issue with something that my colleague said for the joint liquidator. The Swiss court, to my knowledge, didn't say the receiver can't bring these claims. It just didn't recognize the receiver as the representative of Sybil. I'm not aware of specific claims the receiver tried to assert there. Now, that could be true, but again, it's a hole in our record, and it's something that is not before the court, which I think brings us around. I do want to just make my waiver argument, if I may. I really think this is an operation of ordinary jurisdictional principles as established in a series of cases in this circuit and others, including Payne-Weber and Cruson, which Judge Higginson, you've referred to. And the dividing line is between a party hailed into court involuntarily as a defendant and a party who chooses to intervene in an action to pursue a defense, including a defense of personal jurisdiction. However, you don't have to adopt that latter rule quite as broadly, because the courts are very clear that when you do the latter, you voluntarily appear in court, argue personal jurisdiction and merits. You go beyond personal jurisdiction before getting a ruling. You've waived.
The merits argument targeted at the bar order, they're saying you don't have authority over me to enjoin me from my suit in Switzerland.
They went beyond that.
They did go?
They did. They argued that it was unfair, to give away claims for nothing. Not merely that the bar order should be lifted because, and in fact, they said that in their brief at page 12. They say the court didn't allow us to bring our jurisdictional and other objections in the court below. They went beyond mere jurisdiction, and that squarely falls within the entire line of cases. And I would point the court particularly to Transworld, to Payne-Weber, where the Chase Switzerland entity was involuntarily brought into the Texas court and was, of course, allowed to contest jurisdiction and continue to litigate, to Cruson, which Judge Oldham, I believe you wrote, in which the party was challenged for raising jurisdiction too late, but the court correctly found that it raised it as soon as it was able and kept maintaining it simultaneously with an objection to class cert because the timing worked out that it had to do it that way. But other cases like DeBoer, the Eighth Circuit, said that an objector to a class settlement who comes and makes more than an objection that the class settlement shouldn't apply to them, also argues the fairness, has waived jurisdiction not just in the court below, but in the Court of Appeals. Mr. Ho is here for the joint liquidators, arguing the fairness of this settlement. His brief argues the merits of the fairness of the settlement. My light is on. I'm happy to continue talking. I think that the case law is quite clear that there is that dividing line, that as soon as you step beyond when you voluntarily appear in court and you step beyond defending on personal jurisdiction and go to merits, you've waived. And again, I would point the court, in addition, to
the district court was right or wrong that the district court couldn't enforce it?
So, well, first of all,
I don't really see the jails did much more here than they did there.
we don't know because there were no facts asserted. The joint liquidators below in their objection did not submit even the basics that you would have to. If you were a defendant in a case, right, the plaintiff's obligation is only to make a prima facie case. Here, this is not a plaintiff hauling them into court. They've filed an affirmative objection and said there's not jurisdiction over me. Look at Proskauer decided 4 years ago, and then they said the facts haven't changed. No declaration, no supporting affidavit, no evidence supporting it. We were entitled, at a minimum, and I think, Judge Higginson, this goes back to one of your questions, at best, if the court found that the jails were entitled, on hearing that they might lose on jurisdiction, to walk away and somehow still preserve that objection, the most I think this court could do would be remand and say you should have considered, you erred, you weren't entitled in the Chapter 15 to condition their participation in the SEC action on waiver of jurisdiction, and so you should have reached those arguments. I would submit you don't have to do that for two reasons. One, because they went beyond personal jurisdiction and argued the actual merits, and so they've taken themselves outside of that case law. But two, because Chapter 15 made quite clear, and I'm looking at the 2012 decision in Stanford Bank Limited. This is Judge Gobby's decision recognizing the Chapter 15 non-main proceeding. And he said, Section 1509 states, recognition entails that the foreign representative has the capacity to sue and be sued in a U.S. court. And it said, it allows a court at the request of the foreign representative to grant any additional appropriate relief to effectuate the purposes of this chapter and protect the assets of the debtors or the interests of the creditors. A court should similarly condition that relief as it considers appropriate. The court had the authority, and that's citing 11 U.S.C. 1522 A to B. The court recognized, even in entering the Chapter 15 non-main proceeding recognition, that it had the right to condition the jails participating in U.S. litigation on anything it thought appropriate. And here it thought appropriate, conditioning it on submitting to jurisdiction for purposes of the settlement.
3 quick questions. One is, would you agree that the argument that they lack standing even to present the appeal is difficult to reconcile with cases like Castillo and Chagra?
Well, they have a participation problem, right? Did they participate in the SEC action below, or did they not? And they seem to want to have it both ways and say, well, we participated. And they have a huge stake, personal stake.
I'm sorry, I didn't hear. You would agree that they have quite a significant stake to avoid?
I don't think they've even established that, Your Honor, because there's no evidence of what these claims are or what their value is that was presented, even with the objection or the appeal.
That's fine. Second question is, if you don't prevail, both sides have said you still owe the $157 million.
We bore the risk. I can tell you when they argue that this was not an essential part of this settlement, that is dead wrong. We understood that we were taking that risk. It was a condition imposed by the receiver, no doubt because he didn't want to bear the risk, but we undoubtedly paid more thinking that we had this certainty of this bar order.
I don't understand. If your view is that there are no independent claims in Switzerland, then...
No, oh, I'm sorry.
Sorry, please.
The risk was that we wouldn't be able to enforce the bar. We wouldn't have an enforceable bar order against
Right, but
anybody else.
I guess what I'm getting at is if your view is that there's no why, right? That this, you've already settled everything for 157, so I guess they can sue you in Switzerland just like your ex-husband can sue for the exact same thing and get nothing. So why would you pay more for the chance?
That's why we paid $157 million, because we felt that would be the result. It doesn't mean we didn't bear the risk, and it doesn't mean they weren't able to drive a higher settlement by us bearing that risk and by us believing that that was the circumstance that we were settling here. We also would have to look, it's not just the bar order, but if this court finds that the release, I mean, effectively the court would be finding that the release may not be effective. And that certainly is a material condition that we would have to look at and decide whether we were still bound by this settlement.
The protocol wasn't your doing, but you read it closely.
Oh, I've read it, Your Honor. No, it wasn't our doing.
My question there is, am I correct that it seems to assume that the jails were being permitted to sue outside the U.S. without permission from the receiver or the district court? So isn't this bar order inconsistent?
Actually, we've cited the transcript when the cross-border protocol was entered, and the court specifically said, you're not going to take this and argue that I authorized you to go file suits every.
But they didn't need consent, correct?
I think they didn't need consent. I mean, the cross-border protocol, as it speaks to the bank claims and the law firm claims, is nothing more than an agreement not to agree right now. It just says, we'll cooperate in discovery, we won't make arguments that you've submitted to jurisdiction.
It also requires, last question,
Yes.
coordination and sharing. That sure doesn't
Yes.
seem apparent in this record.
Well, that piece is actually important because, again, I heard my colleague, Mr. Howe, argue that somehow there is a different class of people who will benefit from this, from the Swiss claims, right? Because we pointed out that the settlement agreement in our case includes a waiver. Every claimant who takes a piece of that $157 million is required to waive the right to collect anything from any other claims. That was entered, not objected to by any investor. So that leaves potentially a very large piece, if they're correct, if there were any evidence that they have valuable claims, which there isn't before this court or the district court. But if there were, it leaves whoever that narrow group is, we don't know, with a potential enormous windfall, I suppose, because it won't go to the claimants for the receiver. And by the way, that was not the intent of the cross-border protocol. I believe it's section 11.10 that says the intent here is that people will, across both receiverships, will recover in a pro rata equal share compared to their losses. So it was not the intent that some creditor group or some other group collect some greater share.
Okay, Ms. Reed, very helpful, thank you.
If I can just say one more thing about the fairness of the settlement, and Judge Higginson, you alluded to it. We've litigated this case for 15 years now. The joint liquidators have had more than enough time to pursue any valuable claims they might have, and the equities weigh in favor of finding that they're barred.
Thank you, counsel. Mr. Ho?
Thank you, Judge Higginson, and may it please the court. Let me make 3 points about the waiver trap. Number one, it's the only argument that the receiver has for why personal jurisdiction is required. All the other, as we talked about before, they've waived any other argument. You won't find any other argument in their brief or in their papers below. Number two, the receiver's Societe Generale's counsel said that it's not a trap, it's a choice. Payne-Weber makes very clear that's not a choice that any party can validly be put to. And number three, Societe Generale's counsel suggested that we tripped over the tripwire by discussing merits issues and not just personal jurisdiction issues. For one, our discussion of those issues was intertwined with the contention that no personal jurisdiction was required because of in rem jurisdiction. But number two, if you look at Cruzon 954 F3rd at 252, it makes very clear that a party that protests personal jurisdiction while also vigorously advocating its position on the merits does not waive a personal jurisdiction objection. There was a suggestion by the Receiver's Counsel that the appropriate course here would be to await a contempt proceeding. I would direct the court to footnote 19 of the Samnerwood decision, which makes very clear that that is not required. A party that is subject to an injunction and risks contempt if it violates the injunction has standing to object to that injunction. And then lastly, I thought it was telling that the Receivers Council puts so much weight on the Petrosaudi case, which of course is not a case of this court, but more importantly is a case about civil forfeiture, which the court in that case emphasizes is very different from traditional in rem jurisdiction. In fact, the court says traditionally the court must have actual or constructive control over the race when an in rem forfeiture suit is initiated, and then it relies on the fact that Congress abrogated that traditional rule in 28 U.S.C. 1355, a statute that obviously doesn't apply here. If the court has no further questions, thank you. I thank you for your time.
We appreciate all the arguments. This case is submitted, and we will hear the only other case for the day.